Okay. At the end of the session, be sure to return your forms. We'll go through that again. At this point, I'm going to go ahead and turn this over to Will. For those of you that don't know Will Rambo, I did send you out his bio. He's got such a great background and born and raised and staying in the area. So we do appreciate all you do for your community as well. So with that said, take it away.
Thank you, Lori. As Lori said, my name is William Clifford Rambo. Good afternoon, everybody, and I appreciate you stopping in on a fine summer day to hear about the most exciting topic you can imagine, car accidents and car insurance. And there we go. If you guys have any questions, I ask that you put them in the chat. I will try to check them as much as possible. All right. So today we're going to be going over a pretty in-depth overview of Pennsylvania auto insurance and Pennsylvania car accidents. This is going to be both from a client perspective, a normal person perspective, and from an attorney perspective. So whether you want to start doing these cases, you do these cases, or you just want to go home and make sure you have the right insurance, this presentation is going to be for you. With that, we will simply get started. On your screen, you will see a picture-perfect representation of a car accident. And we're going to start off by talking about the main point of this entire presentation. There are certain things that you can control in these cases, and there are certain things that you cannot. And understanding A, that that's true, B, which falls into which category is going to be absolutely critical to you, either as a normal person with car insurance or as an attorney handling these. Point number one, a little bit of a joke point, but it's very, very important. If you ever hear your insurance agent or your client say, don't worry, I have full coverage, ring an alarm bell, put up a red flag, that means two things. One, they have no idea what they have. Two, not knowing what they have, they most likely do not have the coverages that they want to have or that are good for them in Pennsylvania. If you guys hear this phrase, you need to immediately get the insurance policy of the person in question and review. Okay. Next, we're going to talk about generally the two categories of control versus non-control. Obviously, there's a million different coverages you can get. Some are great, some are good, some aren't that worthwhile. In any given car accident in Pennsylvania and probably elsewhere, there's only two realistic places where you're going to get any money for your case. That is the defendant's auto insurance, assuming, of course, that you're not the defendant, and your own auto insurance. Those are the only two real places. Obviously, looking at those two, you can see you cannot control the insurance of the person who hits you. You cannot control what they have purchased, if they paid their premiums, how good or bad their coverage is. The only thing you can control is your own auto insurance and make sure that it's completely up to par and that you have the right coverages. We're going to go over all those coverages in a little bit. One question that you may ask, or if you're an attorney, you will definitely get, I've been doing this 8 years and I get this question at least twice a year, is, well, Will, can't we garnish their wages, attach their property, make a claim to the state, any such thing? And the answer is yes. All those things are technically possible. But in the real world, and especially if you're handling this as an attorney, my description of these is that they are so difficult, so perilous, and so unworthwhile that you should generally consider them off limits. All right, moving on to number 3 here. You are seeing on your screen an old declaration sheet of mine, actually, from a car I leased years ago. Very good car. If you guys ever have a Ford Fusion hybrid, highly recommend it. I blacked out a few things, but we're going to get the general idea of what coverages do what and how much they cost. I'm going to go through these one by one, but I want to draw your attention to the right-hand column where you will see percentages. This percentage represents, for each category of coverage, the percentage of my premium that category costs me. So just real quick, you can see collision coverage. Obviously, that's the kind of coverage you need every day for getting into an accident. That's 33% of my premium. That's the most expensive one. One more I want to draw your attention to, it's towards the bottom, if you can see my mouse, about 3/4 down, is option 1, medical benefit. You will see here that on this declaration sheet, I have $100,000 of medical benefits, and that is only costing me 13.5% of my premium. You'll see the income loss benefits 3%, everything below that's not even a percentage. medical benefits only go up to $100,000 normally on your policy. So what you are seeing is the maximum amount that a person can have in normal medical benefits, and it's not costing you that much. Another one that we're going to focus on, and I want to draw your attention to, is uninsured motorist bodily injury coverage, right in the dead middle of the page, and underinsured motorist bodily injury coverage right below that. Looking at these, you can see they cost 1.5% and 6% respectively of my premium. 7.5 total, of course. That is not a lot. These two that I've mentioned are perhaps the most important coverages you can have, and they are dirt cheap. We're going to go into a little more detail about that. What's my point here on this slide? My point is to show you, if you know what's important, you can get the most important coverages for yourself and your family, or if you're handling it as an attorney, recommend to your client for less money than you'd expect. Again, no guarantees. This was years ago. Maybe prices have inflated, but you get the idea. First two that we're going to talk about are comprehensive and collision. They're very, very similar, but they are distinct. Collision coverage is probably the most self-explanatory coverage we're going to go over today. Anyone here can guess it's when something collides with your car, and that's usually another car. This is a no-fault coverage, and we're going to be hearing that term a lot today. What is a no-fault coverage? Exactly like it sounds. If you get into a collision with another car, for instance, it doesn't matter if you are at fault, aka you ran the red light, you were drinking and driving, you ran the stop sign, etc., or if the other person was. If there is a collision, you get to use your collision coverage regardless of fault. Obviously, in any car accident, there are two outcomes for your car. Either it needs to be repaired, it's worth being repaired, or it's totaled, aka the damage to it is so extensive and so expensive that it exceeds the value of the car itself, in which case you're better off getting a new one. With collision coverage, if your vehicle is totaled, you get the fair market value of your vehicle before it was totaled, of course, minus your deductible. So you're driving around a car that today is worth $10,000 and you have a $500 deductible. You get into a collision, it's totaled, you get $9,500. That's $10,000 minus the $500 deductible. Okay. You obviously get that deductible back if it's determined that the accident was not your fault. Very similar, if the car is damaged, your insurance will pay for the repairs minus the deductible. We are going to talk a little bit about alternate options for property damage. I'm not going to focus on it too much, because if you're an attorney in this field, the primary focus is on bodily injury, of course. But two more points is that there is something called a property damage liability we'll cover in a few minutes on the defendant's policy. That is for when he causes an accident and he causes property damage. However, unlike collision, which is very extensive and it gives you the fair market value of the car, which is wonderful, property damage liability under Pennsylvania law, you can have a minimum of $5,000 on that. You can have a maximum of $100,000, but you and I both know that the average person is not carrying around maximum coverage on their policy. It's most likely going to be closer to the $5,000 mark. And last point on collision, and this just happened to a client of mine. If you ever have a client who gets into an accident, or you get into an accident and your car is sitting on a lot, most likely because it's totaled, do not let it sit there. I guarantee you are being charged something along the lines of $85 a day just for that hunk of junk to be on that lot. And you might get into a fight with the insurance companies as to who has to pay. Comprehensive coverage. I'm not going to cover this too much, mostly because it's being de-emphasized nowadays in my experience, but classic examples are hail hits your car, tree hits your car, deer hits your car, car's vandalized, key, windows smashed in. These should be covered under comprehensive, which has a separate deductible from collision. The reason I say this is not terribly important nowadays is because insurance companies are moving towards lumping everything under collision. I once came out of my grocery store and I had a dent in the back of my car's bumper. It was most likely a grocery cart from, somebody who didn't want to put it away and it blew in the wind. I thought that should fall under comprehensive. My car insurance company said it was collision. Well, something must have hit it, Will, they said to me. Well, if that's your rubric, then everything's collision. Hail hitting your car's collision, tree branch, etc. Do I recommend still having comprehensive? Absolutely, of course. But just realize that you might want to focus on collision coverage and lowering your deductible there a little more. Moving on, we're going to talk about bodily injury and property damage liability coverages. Especially if you are an attorney this is going to be one that you want to focus on more, especially for the defendant who caused your client's accident. As you might be able to guess from the word liability, these are coverages for when you or your client are at fault. So when you run the stop sign, your client runs the stop sign, they blow through the red light, etc. First one, bodily injury liability, covers exactly what you'd imagine. This is coverage for when you're at fault and you cause bodily harm to somebody else. What do I mean by bodily harm? Concussion, broken bones, sore back, broken fingernail, even emotional damage is technically counted. In Pennsylvania, when you look at a car insurance policy, your own or your client's, you are most likely going to see what's called a split limit. Okay. Sometimes it's literally written with a slash, like you see on the screen right now, 15/30,000, 100/300,000, etc. What does this mean? This means the following. The first number, let's take the first example of 15,000/30,000. The 15,000 number is the most that any one claimant, one plaintiff can get from that insurance company. The second number, in this example, the 30,000, is the most that every claimant, every plaintiff arising out of a single accident can get in the aggregate. Obviously, to give some examples, we have to do some math, which we attorneys are notoriously bad at, but I will give you one. Let's say we're going to call him Eddie. Oh, after somebody who is not my client, I know, no duty of confidentiality. Let's say Eddie is on Route 22 and he causes a multi-car accident by failing to stop. He's texting or something like that, and he rams 3 different vehicles in front of him. Multiple people are hurt. In this example, we will say 3. If Eddie has the state minimum, which is 15,000 per person / 30,000 per accident, let's give an example of what could happen. If you have 1 seriously hurt person and 2 less seriously hurt people, in all likelihood, the very seriously hurt person is going to get the full $15,000 of that coverage. That only leaves 15,000 for each of the remaining 2. Different example. If there is a person who gets 15,000 from that same pot, that same 15,000 / 30,000, and there is somebody else who is extremely hurt, they too can only get $15,000. It doesn't matter if their injuries are worth $500,000. Again, people will say, well, once I get his insurance, can I go after his home, go after his wages? Virtually impossible, or at least impracticable in my experience. You have to understand these split limits because you don't want to make a mistake thinking you can get more or less, of course, than you can. Property damage liability, we already covered this, and it's not terribly important for attorneys in this line of work, but I will tell you a funny story. So again, this is for when it is your fault or your client's fault and you cause an accident that causes property damage. Most of the time, that's 2 cars hitting each other. However, it could be mailboxes, it could be walls, it could be tearing up someone's grass. My firm had a case relatively recently where God knows what happened. I didn't handle it. A person drove at full speed through a woman's wall into her living room and ran her over as she was watching TV. Is that property damage? You bet it is. Just not the kind you expect when you sign up for car insurance. Medical benefits. Depending on which personal injury attorney you ask, this is either the most important or the top 3 of the most important categories you or your client want to have. I personally say it is the most important one. Explain why. Every Pennsylvania auto insurance policy comes with medical benefits. The minimum is $5,000. You're not getting any insurance, car insurance in Pennsylvania that has less than $5,000 of medical benefits. The most you can get of normal medical benefits is $100,000. As we saw before, this is relatively cheap. If you flash back to my deck page that I had on slide 3, I had top of the line coverage, $100,000 in medical benefits, the most you can get for only 13.5% of my premium. There's some more advantages to medical benefits under the automobile insurance policies over traditional health insurance as well. You can see them on your screen. No copays, no deductibles, can't get that anywhere else. No subrogation, which means that an insurance company can't come back like Nationwide, which is my car insurance, and say, hey, Will, we paid $5,000 of your medical bills. You want a settlement, give us $5,000 back. They cannot do that under Pennsylvania law. Much broader scope of coverage, no pre-certification, which means you're going to the doctor and getting it paid faster. and like I said, relatively cheap. Generally speaking as well, your medical benefits follow you. The classic example I'll give, and we'll go over this in another minute in a different context, is you're walking down the street, car hits you because it's riding the sidewalk, you're going to get your medical benefits under your auto insurance policy. Why? That's a car accident. It involves the use or maintenance of a motor vehicle, just not your motor vehicle. Generally speaking, subject to some exceptions that we will discuss towards the end, your medical benefits will also naturally, under the law, cover both named insureds, of course, and resident relatives, which means anyone who lives in the same household as you and is related to you. And it's a very broad scope in my experience. I actually haven't found a relative yet who wasn't covered. I'm sure a client will come to me, and please do not ask questions like, what if it's my second cousin twice removed? I have no idea. You'll have to figure that out on your own. But the general ones apply. Spouse, kids, husband, wife, anything like that, it applies. Since we're not in person, I won't ask for a raise of hands, but any motorcycle fans here, you have to understand that you're being governed by a different kind of law. And as attorneys, if we have a motorcycle client, you have to understand that that motorcycle is most likely not going to be governed by the same kind of law. First and most important thing about a motorcycle, it's not going to have any medical benefits in all likelihood. The law does not require insurance companies to give or sell medical benefits for motorcycles. And if they do, it's going to be a completely separate purchase. We're going to be seeing this pattern a lot, that motorcycles are just not treated the same as ordinary motor vehicles. In addition, and this is the most complex part of what I'm going to lecture on today, you will possibly see something when you all go home after this and look at your car insurance. You may see something offered called extraordinary medical benefits. It's called something different from company to company, but that is usually the general idea. Extraordinary medical benefits is a coverage you can elect to get up to $1 million of medical benefits. But there is a huge technicality and catch, which I call the gap, that I'm going to show you an amazing chart I made myself in Paint the other day. Please, nobody laugh openly. So on your screen, you see two graphs, okay? Just for the sake of clarity, and trust me, this is the clearest way to say it. Purple is going to be your regular medical benefits. Blue is going to be your extraordinary, and red is anything you have to pay out of pocket. What I mean by the gap is the following. If you elect to have $100,000 of the normal medical benefits and you get the 1 million of extraordinary, you're well covered. That's the top graph. There's no red. There's nothing you have to pay out of pocket. However, look at the bottom graph. In this situation, we see the purple, or the normal medical benefits, has only been elected up to $50,000. And then this person has elected the blue, or the $1 million in extraordinary medical coverage. What's the problem here? The problem is that the 1 million extraordinary medical coverage does not kick in until you hit more than $100,000 in medical bills. If this is confusing, I will give one more example. Let's say you get into an accident and you have $50,000 in regular medical coverage and $1 million in extraordinary. You end up racking up $125,000 in medical expenses. What is going to happen? What's going to happen is, nationwide, your car insurance is going to pay the first $50,000, no problem. Then you are going to be stuck paying the next $50,000 until you hit $100,000 total paid. And then Nationwide will pick up the remaining $25,000 as part of your extraordinary. Nobody tells you this, and nobody's going to be telling your clients this. Very important to understand this, because a lot of people believe, oh, I have both coverages. I have $1,100,000 in coverage. No, you have 100,000 if you elected that, and then you have a separate 1 million. They are not contiguous. Any questions about that? Just because it is very strange. Okay, great. Moving on to the other most important part of the car insurance policy. This is an issue, limited versus full tort, that in Pennsylvania, I personally despise. However, on a more professional level, I will say that it is an option in Pennsylvania that can make or break a client's case. I recommend that you always have full tort because of how critical this is. We have all heard of pain or suffering. Pain is suffering. I'm sure many of you, whatever fields you work in, have sued for pain and suffering, heard the term, worked with the term, etc. Limited versus full tort is a scheme in Pennsylvania by law that says when a person elects to have car insurance, they must choose one or the other. Limited tort is the lesser option, the inferior option, but it costs less. Full tort is the greater option, but it costs more. The difference is limited tort precludes a person from making a claim and recovering for a claim for pain and suffering. Full tort allows that claimant to make every claim under the sun subject to law, of course. Obviously, I put a little chart on your screen here, courtesy of Excel. Thank you, Excel, to show you that pain and suffering is the only difference. So things like lost wages, outstanding medical bills, whether a person has limited tort or full tort, these will always be available to the claimant. And in my experience working in personal injury for the last 10-ish years, lost wages and outstanding medical bills are not the contentious issue. They are not the thing that the insurance company is going to fight you on generally. Pain and suffering being such a subjective element of the case is always going to be the most contentious part. And obviously with this limited full tort issue in play, it has become even more contentious. You'll see below that there are exceptions to limited tort. Very few, very off the wall generally. What this means is that if you elect to have limited tort and you get into an accident where one of these things happen, for that one accident, you are considered full tort generally. Let's go over these. Death, obviously not one you want to recommend your client rely upon, of course. Permanent serious disfigurement. And this means scarring, and it means permanent and serious. So if you have a small scar in your toe, small scar on the back of your knee, it's never going to fly. The hands, maybe. The face, much more likely. In bold, because it's the most common exception argued by attorneys in the field, is the serious impairment of a body function exception. As you might be thinking, all your lawyer bells are going off. Wow, Will, that's really vague. That's very subjective. Yes, it is. And there is no more statutory clarification on what that means. In my experience and based on court cases, insurance negotiations, our rule of thumb generally is that unless you have a surgical intervention of some kind because of the accident and your injuries, you're most likely not going to meet this. Concussions, you'll see on a future slide. I do a lot of concussion cases, about a 40% likelihood, all things considered, that you meet this standard. Back pain, general back pain, neck pain after an accident, never happened in my experience. A few others, these are very uncommon though. If the defendant who's at fault gets a DUI or ARD, if the defendant's vehicle is registered in a state other than Pennsylvania, the best state, if you are not occupying a private passenger motor vehicle, this is defined as in the MVFRL, the Motor Vehicle Financial Responsibility Law, as a vehicle that does not have four wheels, is not intended for highway use, is a rental, it's owned by a business entity that's not a sole proprietorship, etc. If you're a pedestrian riding a bicycle, if you're on a motorcycle, again, motorcycles, they don't usually have four wheels as far as I know. It means you're always going to be full tort. You're walking down the street, you get hit by a car that's riding the sidewalk, you're full tort. Doesn't matter what you picked. Next one, if you did not sign the limited tort selection form. Hopefully there's no New Jersey people in here, but if so, I'm going to make fun of your state and I apologize. At least Pennsylvania system is better than New Jersey, I always say, in that in Pennsylvania, you are always naturally full tort. What I mean by that is you must sign a form to go from full tort, which you are naturally considered under the law, to limited tort. New Jersey, if anyone here practices or wants to practice in New Jersey, God bless you, the situation is reversed. In New Jersey, you are naturally their version of limited tort, which is called the verbal threshold, and you must elect to go up to the non-verbal threshold, or what we would call full tort. Or if the defendant did not maintain automobile insurance, that is also an exception. All right, little quiz time, guys. I did not come up with this. This is my boss's idea. Take a look at your screen. You will see a truck, and type in the chat if you feel like participating. How many wheels do you think this vehicle has, not counting spares?
6.
I heard a 6. Any other takers? All right, I agree, 6. So after what we just learned, you will see one of the exceptions to limited tort is if you are not occupying a private passenger motor vehicle, which the MVFRL specifically defines as a vehicle, among other requirements, with 4 wheels. Someone said 8. I disagree with 8, but it's better than 4 at least. I actually was doing a live presentation and someone yelled 5, and I don't know what they were thinking. Some kind of weird asymmetrical thing going on there. But since it is a 6-wheel vehicle, aka not a 4-wheel vehicle, my opinion, and we always win this argument, is that riding this vehicle, you have full torque. So if you are a personal injury attorney or you're looking to get into the field, I will tell you right now that 80 or so % of your caseload is going to be car accidents. And that is just the way it is. It's just simply put, more people are hurt in a minute, in all likelihood, in car accidents than they are in slip and falls, dog attacks, puddle accidents, etc. So limited tort is going to be a big part of your caseload and your career. Largely, of course, because a lot of your clients are going to feel betrayed by their insurance agents because they weren't explained this, at least in a way that they feel is fair. And B, people are trying to save money. Who isn't? Again, what's the best exception? Serious impairment of a body function. It's the most objective. It's the easiest one to use logic to try to make a case for. And well, that's what being a lawyer is all about. Again, concussions, really a flip of the coin, very much tilted against you. Oh yes, slide reminded me. This is a real life example of a case I had. Imagine a client who's in a truck accident. He is in a pickup truck, 4 wheels though. He has limited tort and it's a clear liability accident on the defendant's part. Okay, so far so good. He presents to the ER shortly after the accident and they discover through an x-ray or whatever have you, a hairline fracture of one of the vertebrae, let's say in the cervical spine or the thoracic spine, it doesn't truly matter. However, this bright client, deciding to ruin my case, decides to loudly and proudly exclaim to the nurses, "It's perfectly fine. It's not bothering me at all. Doesn't stop me from doing anything in my life. Get me out of here." Well, here's the problem. You may be thinking to yourself, well, hairline fracture, that's a pretty decent injury. It's not a stub of the toe. It's not a sore back. But the problem is the standard is serious impairment of a body function. People will look to what you are actually impaired from doing. This person proudly proclaiming, "I can do everything under the sun," that lost him the case on the limited tort issue. And frankly, I think that was the right decision, even as a plaintiff's attorney. If somebody can do all of their life activities, it's not in the spirit or the letter of the law for them to get this exception. On the opposite note, of course, the more that you can show that their injury impaired them from doing things, the more likely you're going to win on this exception. The biggest hitter is employment. If they couldn't do their employment because of some kind of pain, some kind of inability, some kind of incapacity after this, that's your number one winner. Hobbies, they come in a far second. Just not as powerful to an arbitration board, insurance company, or a jury saying, well, it's a serious impairment of body function because I couldn't go bowling. Nah, it just doesn't sound as good. Try to focus on your client's employment or obligations of that nature. I almost always forget to mention this, but please be aware, and I'm not going to go over which are which because it would take too long. Most of the exceptions to to limited tort that I just mentioned, they don't apply against your own insurance carrier. We're going to talk about in a minute, again, how you can go after the defendant's insurance and then you go after your own insurance. Most of these exceptions do not apply once you start going after your own insurance. They only generally apply to the person who caused the accident. So again, you try to go after your UIM and you have one of these exceptions that doesn't apply, they're going to tell you, sorry, you have limited tort. You're right back to arguing the subjective serious impairment of a body function standard. Okay. UM and UIM coverages. This stands for uninsured and underinsured motorist coverage. And depending who you ask, this is the most important part of your policy. I say it's second or third. These are coverages that you purchase on your own car insurance. And the purpose of these, respectively, is to protect you in the event that the person who hits you, assuming it's their fault, has no insurance or doesn't have enough insurance. A couple notes on that. You may be saying to yourself, but Will, it's illegal in Pennsylvania not to have car insurance if you have a registered vehicle. That is correct. It happens anyway. What do I mean by not enough insurance to cover your client's injuries? Well, imagine, use another example from a recent one. Imagine you have a client who's on a motorcycle and he had a clean fracture of his back. What I mean is not a hairline, not a comminuted fracture, just the back was completely severed at one point in the spine. That's going to be a very, very serious injury with a lot of compensation due to him, assuming it's not his fault, of course. What if the person who caused his accident only has $15,000 in coverage? Well, he wants to have a ton of underinsured motorist coverage. You know, hopefully he'd have 500,000 or a million, whatever the most is you can get. Obviously, in a situation like that, you're only going to get 15 from that person at most. Then you want to get the rest from your UIM. If you don't have UIM or you don't have enough, even with that serious of an injury, you're going to get 15,000 from the defendant and pennies from whatever your UIM will offer you. This is why, again, going back to the notion of control versus not control, you cannot control the defendant, their behavior, their insurance. You need to control your own ability to protect yourself, or obviously if you're recommending insurance to a client. Couple things on this that is very, very important. It's a split limit, just like bodily injury liability. So you see on my example here, 250,000 / 500,000, same kind of scheme. There's something else that's very important though. Imagine you or your client is driving in a friend's car. Let's call him Will. And Will is driving perfectly, as he always does, when somebody else, probably a driver from New Jersey, runs through a stop sign and hits him, causing an accident. In that situation, you actually have 3 sources of recovery as opposed to the normal 2. What are those 3 sources of recovery in order? The defendant driver who caused the accident, you go after their insurance, number 1. Can't control that, of course. Then you as the passenger actually go after my UIM insurance, assuming, of course, that your injury is substantial enough to justify more compensation. That doesn't require me to have done anything wrong. Like I said, I'm always a perfect driver. It's always those people from New Jersey who are hitting me. Then, assuming again that your case is worth enough to justify even more, you then go to level 3, your own UIM insurance. So what am I telling you? I'm telling you, if you're in somebody else's car, make sure to look to their UIM, and also it benefits you not to be driving. UIM, the amount you can buy is a little wonky, which is a technical legal term. So I have on your screen the 50,000 / 100,000. Just as an example. In any given situation, you can only purchase UM and UIM coverages up to what you have in bodily injury liability. So again, bodily injury liability is one of the first ones we talked about. It's when you're at fault and you cause injuries to somebody else's body. If you only have 15,000 / 30,000, as I continuously said, the state minimum, the most you can get in UIM and UM is 15,000 / 30,000. So while this is relatively cheap, it comes with that caveat that you got to increase the other one, the bodily injury liability. Unfortunately, you can also waive this completely. What I mean by that is purchase 0 of UM UIM. You do have to sign a special form. The default in Pennsylvania is to have UM UIM, but you can get none of it. Do I recommend doing that? No. Why? This right here, to protect yourself in the event that a driver with crappy insurance hits you, this right here, UM and UIM, is the best way to protect yourself. You could have $1 million of this, and then you don't have to worry at all if an uninsured or underinsured driver hits you. Well, you still have to worry, but you won't be worrying on the legal side. Stacking. Stacking is a curious beast in Pennsylvania, and actually it's a subject of much debate right now in the Pennsylvania Congress. If my buddy TJ Schick, another attorney in my office, were here, he would take the next 20 minutes to explain a bill that they're trying to pass to get rid of stacking. I will spare you that because, you know, it's already as boring enough as it is, car insurance. Stacking is the idea that you can multiply your UM, UIM coverages. The most common way to stack is A, to elect stacking, okay? Make sure you have it, of course, as an option. And then to put multiple vehicles on the same policy. On your screen, you will see an example, a 2020 Hyundai Tucson and a 2011 Kia Forte. That's 2 vehicles. What does this mean? Well, you see in front of you example, UM UIM is elected in the amounts of $50,000 / $100,000. In this example, you would simply multiply that number by 2. So instead, you would have $100,000 / $200,000. I've met people who have 11 cars on a policy. I mean, I don't know how big that family must have been, and they had stacking. You know, at some point it becomes a math problem, which again, we're notoriously bad at as attorneys. But long story short, this is a very effective way for families that have multiple vehicles to multiply their coverage without having to play the game I mentioned a minute ago of increasing your bodily injury liability. Does this cost more? Yes. In my experience, it doesn't cost as much as upping your bodily injury liability. There is also inter-policy stacking. What do I mean by that? Imagine you have the Kia on one policy in the household, and you have the Tucson on a different policy in the household. If both policies have stacking, you're most likely to be able to stack that. Now, like I said, stacking is the subject of much controversy right now. There's been multiple court cases, which we'll talk about in a minute, that have been challenging it, trying to expand it. It's getting appealed. As of right now, stacking is A, the default under the law, and B, favored. Again, keep an eye out, though, if that's going to change. Last point, I'm going to skip most of the slide. We already talked about all of it, but there is a government fund in Pennsylvania. And I'm only telling you this because I would feel as though I was misleading you if I didn't inform you, but it is a very bad last resort option. If you have a client or a person who was in a car accident, they have absolutely no car insurance. They don't live in a household with anyone who has car insurance. They don't have a car that's supposed to be insured. And the defendant who hits them has absolutely no car insurance, obviously, despite the fact that that's illegal. There does exist a Pennsylvania fund called the Pennsylvania Financial Responsibility Assigned Claims Plan. We call it the fund to avoid the mouthful, where such a person might be able to qualify for up to $15,000 because of an accident. We're going to go into much more detail about this. As a cliff note, it's horrible. Try to avoid it in your careers. All right, we are going to move on to the much more exciting topic of recent court cases involving some exceptions or exclusions to car insurance policy. You all know insurance. Obviously, I'm sure you have insurance on a million things in your life. You know that insurance has plenty of exceptions. Car insurance is absolutely no different. We're going to talk about two right now, and that is the household or family car exclusion and the regularly used non-owned vehicle exclusion. The household or family car exclusion is an attempt by the insurance companies to pull back on the resident relative doctrine. So again, if you live in a household with someone you're related to, generally your car insurance will cover that person as well, and their car insurance will cover you. The household or family car exclusion tries to take that away. Let me give you an example. The classic example, and this is a case called Gallagher versus Geico Indemnity, and we are starting talking about this at 12:39, if anyone's participating by phone, was a situation where Mr. Gallagher, he had a motorcycle on one Geico policy, and then he had cars insured on a separate Geico policy. He got into an accident on, let's say, the motorcycle. Okay, well, you can make a claim against the defendant. You can make a claim against Geico for UIM, assuming it's appropriate. But they didn't let him make a claim on his car insurance policy with his regular sedans. And he felt as though he should have been allowed to do that. Geico said, no, we don't think you should be allowed to do that. We have this exception here. Mr. Gallagher did a very, very unique argument where he said, under Pennsylvania law, under the MVFRL, stacking is the norm. Remember I said full tort is the norm. Having UIM is the norm. Stacking is also considered a norm, the starting point, the default. Under Pennsylvania law, the only way to get rid of stacking is to sign a special form. He argued, sure, you have this exception, Geico, but you never had me sign the stacking waiver form. Therefore, under the law, I am presumed to have stacking. And like we said last slide, inter-policy stacking is allowed. Well, the court agreed. That doesn't fully invalidate the household family car exclusion, but it did a number on it. Still something to look out for, though, and something you got to be very cognizant of if your clients come to you asking you to assess how good their coverage is. Now, one of the good ways to get around the family car exclusion is simply to make a named insured anyone and everyone that you could ever hope to cover. Your daughter, your son, your dog. I'm kidding, but you get the idea. That way, they're not subject to the family car exclusion because they're not being covered as a resident relative. They're being covered as a named insured. Moving on to the regularly used non-owned vehicle exclusion, which frankly, I enjoy this one much more as a concept. I'm being a little snarky in my slide. What was the regularly used non-owned vehicle exception? Hint, hint, it's gone as of right now. This was an exclusion whereby your personal automobile insurer didn't have to cover you for UM or UIM if you were using a vehicle at the time of the accident that you regularly used but did not own. That might sound like a tongue twister. So let's use a basic example here. Another one of my cases that I handled in the last 6 months. Imagine you're a UPS driver and you are parked on the side of the road, digging through the back of your truck, getting ready to deliver an Amazon package to Will's house. Thank you very much for your service. All of a sudden, an elderly woman unfortunately does not perceive the road correctly, and she rear ends your parked vehicle. Okay, well, let's go through everything we've learned. You're allowed to go after the woman and her car insurance. It's obviously her fault. That is correct. And in this situation, in real life, she had 15,000 in coverage, like the nightmare situation I always warn about. Okay, then we think to ourselves, okay, well, you're in somebody else's vehicle, so we've learned that you can then go after the UIM coverage of the vehicle you were in. So have Mr. Client go after the UIM coverage of the UPS truck. That's a wonderful idea. Hint, hint. UPS does not have UIM coverage. You have a client who is driving for UPS, 99 times out of 100, there's going to be absolutely no coverage, and he can do nothing about it. Obviously, he is not Mr. UPS. He is not the CEO. He is not the board. He cannot control that. Okay, then we'll go to step 3, getting desperate here. We will try to make a claim against Mr. Client's nationwide, his personal automobile insurance policy. That's where this exception kicks in. Even though Mr. Client had $100,000, probably exactly what his case was worth, in my opinion, of UIM coverage, and he only got 15 from the defendant who hit him, they would have invoked the regularly used non-owned vehicle exception. Why? Mr. Client drove the UPS truck every day. Mr. Client does not own the UPS truck. It is the definition of regularly used non-owned. The other most classic example is police officers. Police officers, they drive to work in their own car and they get in their police cruiser. They don't own the police cruiser, but they drive it every day. It's regularly used non-owned. So police, in my experience, I imagine ambulances would be too, but police, in my experience, are the most likely to be caught up by this exception. Thankfully, thanks to 2 attorneys in my office, and they are very proud, I can take no credit for it. I did not help them. 2 attorneys in my office actually were behind the case, Rush versus Erie Insurance Exchange, that invalidated this exception at the Superior Court level. So as of right now, statewide, this exception does not exist. However, after drafting these beautiful slides, I have been informed that the Supreme Court is taking up an appeal on it. So fingers crossed, we'll have to see what happens. But right now, this exception is dead. Okay, I'm going to be serious for a few minutes because we were talking about something so important as attorneys and as clients that you cannot miss it in your cases. Subrogation. You guys probably have dealt with it in different contexts. This is the most complex part of any personal injury motor vehicle accident case. Subrogation, again, is the idea that a third party, most likely an insurance carrier, has the right to come to your client and say, hey, client, you just won $100,000. Congratulations. We paid for $50,000 of your medical bills. Give us $50,000. You don't like that. Your client doesn't like that. And in my experience, they blame you somehow for it. Here's the strange part. The strangest part is that subrogation is illegal in Pennsylvania, which may make you wonder, then why is it so important? Section 1720 of the MVFRL, only reading the bolded parts, I'm not going to bore you guys. In actions arising out of the maintenance or use of a motor vehicle, there shall be no right of subrogation or reimbursement from a claimant's tort recovery. Should be the end of the story, right? No. In a truly unique circumstance that probably doesn't happen often, the biggest problem with this law is that parts of it, or at least sometimes, this Pennsylvania law is federally preempted. We don't deal with this much, but if you go back, Article 6, Paragraph 2, United States Constitution, reading the bolded parts, this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary, notwithstanding. A very 18th century way of saying, if the federal government has a law, assuming that it's fully authorized, not unconstitutional, you get the idea, and it contradicts a state law such as Pennsylvania's, well, guess who wins? The federal law wins. And the federal law qualifies certain types of insurance companies, health insurance companies mostly, to get their money back, to subrogate against your client's case. One of the most common ones that I deal with, for instance, is ERISA, which stands for the Employee Retirement Income Security Act of 1974. Any health insurance company that qualifies under ERISA is most likely to be able to get their money back. As attorneys, the reason this is so critically important can be best shown to you by an example. An example is, let's say you have a guy He got banged up in an accident. It's not his fault. He's got some back pain, went to physical therapy, went to chiropractor. You get him a nice $10,000. He says, great, which is the unrealistic part because we know that he would, demand $1 million, but you get him $10,000. He's happy. And then you give him his money, you take your attorney's fee, you call it a day. Next day, you find out that you didn't pay attention to the subrogation issue and that there's an ERISA qualified health insurance company and they are demanding $7,000 from your client. Guess what your client's going to have to do? Pretty much give him the entirety of his in-pocket net amount that he got from the case. If he's not going to be happy with you or with the situation. For ERISA cases, for self-funded, under ERISA, one of the key flags for whether the entity is allowed to subrogate money is whether it's self-funded by general assets of the sponsor. Ask them for their Form 5500. Okay, there is a section on there that can tell you whether the health insurance company is self-funded. It's not the end of the investigation. I won't go into it in too much more detail. We'd be here all day and night, but that is your best starting point. If you have a client or a friend who's trying to handle their own car accident case, they need to know this because they never know this. And they think, oh, all right, I'll settle for $5,000. They never know that potentially, if their health insurance pays something, that potentially subrogation is coming. My experience, I don't think there's any car insurances that are qualified in this way, so they never get their money back. Health insurances, it's about a 50-50 in my book, in my experience. Oh, funny little picture. You ignore subrogation, you throw money away. And then you probably get sued for legal malpractice, which is not as easy to put into a comic, but some hints on subrogation here. And let's see our time. Okay, I'm going to try to finish up here, obviously. Medicare. Sure, you guys deal with Medicare. Medicare will always reduce the lien by attorney's fees and costs. They have a whole formula for it. They have a crappy worksheet you can use. Contact me. I actually have an Excel spreadsheet that can calculate it for you if you ever need it. It's much easier than working with their forms. Workers' compensation, they will do the same. Okay, you may see back in this statute, section 1720, I crossed out workers' compensation benefits. Even though those words appear in the statute, it has been amended and just no one decided to amend it in the actual text. So workers' compensation benefits are also able to subrogate. They also have a worksheet. Don't use it. Email me, I'll give you an Excel sheet that's much easier to use. Workers' compensation liens cannot subrogate against your client's personal UM or UIM. What do I mean by that? Take Mr. Client, who's in the UPS truck again, okay? Again, what happened with him? He went after the woman who hit him, got 15,000. Couldn't get anything from UPS because they had no UIN. He went after his own UIN. We won, got him $100,000. Workers' comp is not allowed to take any money from that, even though they have a legitimate lien otherwise. They took all of his money from the woman who hit him, the defendant. They cannot touch the 100,000 he got from his personal. And do not let them lie to you, either through negligence or maybe they're just trying to get more money. They will sometimes tell you the opposite. Tell them they're wrong. What happens if you have a lien that's way bigger than your settlement? 99 times out of 100, what you want to do is, let's say you can only get $15,000 for a guy. You have a $450,000 lien. Just propose to the lien carrier. How about I, the attorney, take a third, 5,000, give my client 5,000, a third, and you take a third. They will most likely do that. And the reason they'll do that is because of the last one. Threaten to drop your case with your client's permission, of course. If a lien holder will not reduce the amount they're asking for, they're only able to get that money from the recovery of the lawsuit. They can't go after your client's general assets generally. Threaten to drop the case may give you some negotiating ammunition. All right, if you guys thought you were bored before, this is when it gets really bad. Let's talk about the Pennsylvania Financial Responsibility Assigned Claims Plan. Again, this is the government fund in Pennsylvania where if your client has no insurance, isn't supposed to have insurance, has nobody in the household, resident relative that has insurance, and is hit by a person who's at fault, who does not have car insurance, no insurance anywhere, you can apply for your client to this fund. The most your client can get, $15,000. But the requirements on this, guys, and the ways that a client can be excluded are extreme. I'm not going to read this off to you, but generally, your client has to be a resident of Pennsylvania, has to be injured because of a motor vehicle accident. That's the easy one. It's not an owner of a motor vehicle that's supposed to be registered and insured. Is not entitled to receive any first-party benefits. There's also grounds for ineligibility. such as your client can't be intentionally trying to injure himself or another while getting into the accident. Can't be committing a felony. So don't represent anybody who's fleeing from the cops in a stolen car. The fund's going to deny you. Again, number 3, evading lawful apprehension. Or number 4, while knowingly converting a motor vehicle. I guess this is literally built for Grand Theft Auto clients. Last point of math here. In addition to up to the $15,000 for what we'll call just pure pain and suffering, your client can get up to $5,000 of approved medical bills, but it's not in addition to $15,000. It subtracts out of the $15,000. So not really worth it if you feel as though you can get $15,000 on pure pain and suffering alone. All right, we are wrapping up, and then I'll take any questions. Looks like we're right on time. What else matters in a personal injury automobile accident case? I mean, honestly, I think these matter in all personal injury cases, but that's a seminar for another time. Comparative fault. In our system, our civil system, most of you probably know this already, not all of you, we have a modified comparative fault system. What does that mean? It means you go to court, a jury's going to assess if there is comparative negligence, aka your client was also partially at fault in their eyes. What percentage was your client's fault and what percentage was the other defendant's faults? Okay. If your client gets any amount of comparative fault, 50% or lower, he still recovers, which is great. But they're going to reduce the award, the verdict, by that amount. So if he wins $10,000, but the jury says it's 50% his fault, he's only getting $5,000. Once you hit 51% or higher of your client being held as culpable, as negligent, you get 0. That's why it's a modified comparative fault system. I guess there's some states out there where you can be 99% at fault and still win, you know, a few dollars off your verdict, but that's not how we work. Pre-existing injuries. As an attorney, this is the most important thing for your damages case. Sure, what happened to your client matters, but it almost matters just as much what his condition was before. Technically, yes, we are in an eggshell plaintiff state, which means that if someone has plenty of problems or is very weak, easily hurt, etc., and he is hurt, you're not supposed to hold that against him, but does not change the fact that pre-existing injuries can create a causation issue. What I mean by that is, use this example. Let's say that I'm hunched over all day doing CLEs and I have a really bad neck because of it. Really hurts all the time. And then I get into a car accident, again, not my fault, probably a New Jersey driver statistically, and it causes my neck to hurt even more. The only part of that injury that driver is going to be able to recover from me is the additional aggravation of my neck injury. We're going to have to separate out how much pain and what kind of problems for my neck was pre-existing and how much was after the fact. This is the #1 avenue if you are a plaintiff's attorney that defense attorneys will effectively counter you, and you have to be ready. Interview your client, ask them about their medical history, assume they're forgetting stuff or lying, and order up their past medical history. It's worth the money. Gaps in treatment. You do not want to have a client who goes to the ER today and then the next visit to the doctor 6 months later and they're claiming that it's a life-altering injury and that they can never love or work again. Jury's not going to believe them and you're not going to have the medical evidence to back it up. In the same vein, if anything your client says contradicts the medical records, it doesn't matter if they're right. The medical records are always going to be believed over them unless you have some great way to corroborate your client's story or impeach those medical records' credibility. And in my experience, clients are wrong more than the medical records, of course. Litigation costs, risks of proceeding, you guys probably already know this, but you don't want to go to court on a case that you think is only going to get $3,000. You're going to spend more in deposition costs than you're going to get. Risks, obviously, if the case is worth $3,000, the risk of a jury coming back with a number that isn't worth it is much higher. Back charge. I mentioned before that in Pennsylvania, full tort, stacking, and UM/UIM are the default. They are the natural state of human beings, according to the MVFRL. What I didn't tell you is, I'm telling you now, is that if you have limited tort, if you don't have stacking, if you don't have UM/UIM, and then it's discovered you did not sign the forms required to elect those lesser options, congratulations, you have full tort, stacking, and UM/UIM. The bad news is they're going to back charge you $10,000 or whatever it is from the date that they made the mistake. This is negotiable. Okay. I've had this happen to clients. You can negotiate with the insurance companies. They understand it's a Hail Mary. Okay. Argue unilateral mistake. That's my experience. Gap insurance, I'm going to go out of order here. Gap insurance is if the car you're driving has a lease or a loan and it's worth more than what the car is worth, you want to have, or your clients want to have gap insurance to cover that difference. And then recent health insurance cutoff. This is a very strange one. My buddy, another young attorney at my office presented to me, TJ Schick. He reviewed the policy language of a health insurance policy that said, and I've never seen this before in my life, hopefully never will again. If you settle a claim for an injury, which is the whole idea, you can never use our health insurance to pay for that injury's treatment again in the future. Mind blowing to me. I don't think it's illegal, but terrifying from a plaintiff's point of view. Last slide, and then we'll take questions. What's the point here? The point here, whether it's you or your client, there are forces you can control and forces you can't control. There are pitfalls. A lot of car insurance is really straightforward, which I can't say about a lot of statutes in Pennsylvania. Some of it's full of pitfalls, some of it's full of curveballs. And understanding what's easy, what's not, what's effective, what's not, and what's coming in your case or not can help you both as just a driver in Pennsylvania, which we are, even as attorneys, and as attorneys. Your clients, your friends, tell them the time to make sure your insurance is good is now, because I think it goes without saying, if you get into an accident the day before you change your insurance, those changes aren't effective for that accident. All right, I will take questions. Otherwise, thank you guys for listening to me for the last 55 minutes and good luck with everything. Take care.
Just a housekeeping item, be sure to send your credit forms into Denora. You can email them to info2@monroebar.org. You can fax them to 570-424-8234. And if you have any questions, I'll be sure to send everyone Will's email address as well, so you have it.
Oh, yes, please. Yeah, if you guys have any questions, even if just not even as an attorney, just as a person who, like many people, freak out after this little lesson and say, oh my God, what's my car insurance? Send me your deck page. It's called a declarations page. I'm happy to review it for you. Okay. And thank you, Lori. I appreciate everything.